What are we waiting for?
What's on the
For-
calendar?
No,
What's
wait.
on the calendar?
VJ coming in?
VJ did not email as like sick or got better. Like I don't know what happened here. Do you have handouts? Debbie?
I do, yeah. Should I do it now, maybe? We're not going to get to this for a little ways in, but these are there are a series of new forms that we're going to have, and I'm going to go through one of the forms in the presentation. So,
Thanks.
Is this the new one? And
Yeah.
It's not draft anymore, right? This is like a
Right.
barcode and everything ready to use.
right, right.
You don't
Except
have
we're
have
yeah.
it on the
they're
floor.
good. It's going to be on the floors, yeah.
When this is gonna
I mean, it
start?
should be, momentarily. I mean, Joanne Coffin's in charge of getting these forms, so I don't know exactly where it is with the printer, but they've been approved, and
So if like there's a case and I can make copy of this and use it and put on the chart, it would be okay?
probably, although there'll be like an official one. This, this has this weird band on it here and stuff. I mean, but it's substantively it's the same. So, but I think what we're going to do though, when we start to use these, is to throw out all the forms that we're currently using and like officially move these in onto the floors, and we'll get rid of all the DNR forms, and so.
Would be nice, yeah. Can you tell us about yourself?
About myself, sure. So I'm Debbie Korzenik. I'm one of 7 lawyers at Continuum for Continuum Health Partners, and I've been here for many years. I do a lot of different. I function in a lot of different legal areas, but I do a lot of the patient care and medical ethics issues. I sit on the ethics committees at both Beth Israel and St. Luke's Roosevelt, and I've served on the bar associations on health law and medical ethics, and I'm delighted to be here today, and I'm apparently being taped, so if you have, I don't mind answering questions, but I think they prefer to do it at the end. But if there's something that's, as I'm speaking, that's, you really need clarification on, please, feel free to jump in, so.
So are you recording?
Yeah.
So, okay. So I'm going to talk about medical decision making in New York in general, and tell you about the sort of the legal landscape and a little bit of the history, and then we're going to focus on other laws in New York having to do with medical decision making, and then we'll focus on this new law, the Family Healthcare Decisions Act, and our implementation of it, and we're going to be rolling out new forms, and we'll focus on one form in particular that I think will be used often. And then at the end, I have a couple of case presentations that will hopefully sort of help with, understanding the new law. Let's see. Press here. This isn't quite.
That arrows might help you.
It's not.
No.
Oh, that one. Okay.
Something's happening.
Yeah, that's the one. Oh,
Okay.
There we go. Okay. So, the healthcare decision law was passed. New York was one of the only states in the country without a surrogate decision-making law. I think Missouri was maybe the only other. And so New York law was deficient in providing family members authority to consent to beneficial treatment for patients without capacity, but it made no practical sense not to rely on family members to consent. So we have always had family members consent for indicated care. They were never legally authorized to do so, but that was never a problem, and it worked pretty well. The issue was always in New York was for the standards of withholding and withdrawing care at the end of life that was problematic. So I would just sort of summarize that the long-standing New York law for end-of-life decision-making, there were sort of 3 broad principles. One is the principle of patient autonomy, which is that patients with capacity have a right to consent or decline treatment, even life-sustaining treatment. And New York courts relied on common law. There was no statutory law really on this. It was, we have an informed consent, but it was the Starr matter in the New York Court of Appeals, O'Connor, Court of Appeals wrote that living wills are ideal. And then there was the Supreme Court case, Korzenik, that basically supported the proposition that you needed clear and convincing evidence to withhold or withdraw care. Korzenik basically found in the 14th Amendment that an adult patient has the right to refuse unwanted medical treatment, and that's a liberty interest that's protected by the Constitution. The second principle is that life-sustaining treatment can be withheld or withdrawn if there is clear and convincing evidence of a patient's wishes. And then the principle 3 is really just the flip side of that. If there's no clear and convincing evidence, it's legally required to continue to provide life-sustaining treatment. This was the regime that we worked under for years, and it was fairly problematic. I think our institution did a very good job of navigating this, but it was difficult. So this new law is very helpful and gets rid of this standard, basically. So in the years since these cases, the New York State Legislature approved 3 sets of circumstances when life-sustaining treatment can be removed without clear and convincing evidence. The DNR law, which we all know in that very narrow area about CPR, there were ways to withhold or withdraw CPR without clear and convincing evidence. The healthcare proxy law, of course, which permits a patient to select a decision maker before they lose capacity. And then that agent can make a decision based on the patient's known wishes, if not known in their best interests. And then the Healthcare Decisions Act for the mentally retarded persons, which allows for the designation of a guardian to make decisions regarding withholding and withdrawing of life-sustaining treatment on a patient with mental retardation or developmental disability. So then there are other laws too that we have that facilitate end-of-life decision-making. Both federal and state laws require us to follow a patient's advance directives. There's also the Federal Patient Self-Determination Act recognizes the rights of patients to direct their own health care. It also requires us to honor advance directives. Just very quickly, I know you all know there's written advance directives are either living wills, less formal written documents, or healthcare proxies. The documents that appoint a healthcare agent may contain specific instructions. And then oral advance directives are witness statements made by the patient expressing wishes about medical treatment. So just sort of summarizing the legal landscape, the DNR law authorizes family members and friends to act as surrogates for decisions with regard to withholding or withdrawing CPR only. Healthcare proxies allow family and friends to make any healthcare decisions the patient would be authorized to make as long as they had been appointed by the patient before they lost capacity. And then the Family Healthcare Decisions Act, which fills in that gap, it significantly broadens the scope of surrogate decision-making in New York by empowering family members and friends to act as surrogates for patients without capacity, even if they were not appointed by the patient and even if the decision does not involve CPR. So what is this new law? And I'm just going to give you an overview of the key provisions, and then we'll go into detail on this Form 4. So the Family Healthcare Decisions Act empowers families and close friends to make treatment decisions for patients who do not have the capacity to decide for themselves. It provides a process for physicians to make healthcare decisions for patients without capacity who have no one to speak for them. So that's a very helpful aspect of the law too. Even if there's no surrogate, it provides a process for that. It applies to patients in hospitals, nursing homes, and then it was more recently extended to hospice programs in New York State. It absolutely does not apply to a patient who has signed a healthcare proxy. So if the patient has a proxy, you're not in this law. You follow the healthcare proxy law. It does not apply to patients with mental retardation or mental illness or developmental disability receiving care in a hospital, psych unit, or state-licensed OMR or OMRDD facility. This aspect of the law is very tricky because a group of us with implementation of this law, and I'm on the working group, have put together a very complex chart with literally 14 categories of patients and which laws apply to them in terms of medical decision making, and it's really a real puzzle, and it's complicated and unfortunate. I'm hoping the legislature is going to deal with it, but at the moment it's a difficult part of the law. It repeals the clear and convincing evidence standard for end-of-life medical decision making, And like the healthcare proxy law, it provides that all healthcare decisions be made on the basis of the patient's known wishes, if not known in the patient's best interests. But unlike the healthcare proxy law, to withhold or withdraw artificial nutrition hydration, the agent does not need to have been informed by the patient of his or her wishes. The healthcare proxy has that requirement that in order to withdraw artificial nutrition and hydration, the patient has to have had a discussion or written down in very clear language for the agent their wishes on this. The Family Healthcare Decisions Act does not require that. It can be made on the basis of the patient's known wishes, if not known best interests. I think the legislature is going to deal with that too. It makes no sense to have an agent have one set of rules for this and the surrogate another. Like the healthcare proxy law, it requires that advance directives be honored. It also allows a surrogate to consent to HIV testing and HIV care. It's not explicit on that, but the Department of Health has said that that's what it means, and there's also a new HIV law in New York that's very specifically permits a surrogate to consent to HIV testing and HIV care. It mandates all patients and surrogates receiving that they receive a Department of Health publication summarizing the rights and obligations under the Family Healthcare Decisions Act, and that should be in the admitting packets. Okay, so I'm going to just describe to you the new forms under the Family Healthcare Decisions Act, and there are going to be 6 of them. The first 3 forms, Form 1, which is an adult patient enabling the surrogate to consent to treatment. 2 is just simply documentations of a patient's domestic partner or close friend. And 3 is an adult patient without a surrogate authorization for major medical treatment. These 3 have to do with beneficial care when patients consent to treatment. I'm a little concerned about Form 1 because it's going to add a sort of another form to the typical consent when a patient lacks capacity. The law doesn't require these forms, but it does require this documentation. So it kind of walks you through the incapacity determination and then the list of surrogates and making sure the appropriate surrogate is the decision maker. So those are the first 3 forms, and then the Form 4, 5, and 6, 4, which is the adult patient, surrogate consent to withhold or withdraw life-sustaining treatment, including CPR. Form 5 is an adult patient without a surrogate to withhold or withdraw life-sustaining treatment, and Form 6 is withholding or withdrawing on a minor. Those 3 all have to do with end-of-life decision-making. So the Family Healthcare Decisions Act repealed New York's 20-year-old DNR law, except with regard to non-hospital DNR orders. Because of that, all 8 of the prior DNR forms that we've all been working with will no longer be valid, and these new forms will replace them. So the DNR orders for patients with or without a surrogate will be written on the same basis now as any other order to withhold or withdraw life-sustaining treatment, and those are those last 3 forms that I just indicated. But then we had this problem with how we're going to write DNR orders for patients who have capacity, who want to make themselves DNR, and then a patient who has a healthcare proxy. Because if you have a healthcare proxy, you're not in this law. This law doesn't cover you. So how do those DNR orders get written? So in order to create symmetry between decisions to withhold or withdraw life-sustaining treatment made by surrogates under the Family Healthcare Decisions Act and the same kinds of decisions made by patients and their healthcare agents, we developed 2 new forms that on our DNR life-sustaining treatment policy. So the first one is the DNR Form 1, which is an adult patient with capacity. It's very similar to the old DNR form where a patient with capacity makes themselves DNR, except that this will include other types of treatment to be withheld or withdrawn. And then the DNR LST Form 2, which is a patient without capacity who's designated a healthcare agent, and it's for the healthcare agent to withhold or withdraw life-sustaining treatment, including CPR. And then 2 DNR forms survive from before, which is the new DNR Form 3, which is DNR in the OR, suspension or maintenance of the DNR order during and after surgery, and DNR Form 4, the non-hospital DNR order, and that'll be the same form as before. It directs emergency service personnel and hospital emergency personnel not to attempt CPR in the event of a cardiopulmonary arrest. That's a state-mandated form.
Can I ask a question about the form tree? There is such a thing that people think that when you go to the OR, you have to alleviate, you have to be CPR. You cannot go on a DNR. Is that such a thing? Because according to that, it is not. You can maintain your DNR even though going to surgery. Is there?
Yes, I mean that's been the case for
All
years.
along,
That
isn't it?
form has existed all along.
Okay.
And it's signed by the surgeon, the anesthesiologist, the patient, or surrogate. And it also, the form allows you to sort of pick and choose what aspects of CPR you might want, and something you have to discuss with the surgeon. I mean, there may be, when this form was first implemented, there was a lot of discomfort on the part of the surgeons and anesthesiologists about it. So, you know, there has to be a discussion about how to move forward, but there is that option, definitely.
There is.
Mm-hmm. Okay, so now we're going to talk very specifically about the forms you have in front of you. Family Healthcare Decisions Act Form 4, which is an adult patient without capacity, surrogate consent to withhold or withdraw life-sustaining treatment, including CPR. So the very first thing you need to do is confirm there's no healthcare proxy, because if there is one, then this law doesn't apply. The first,
Can I
yeah.
ask a question about that?
Sure.
So if there's a healthcare proxy, because I think you said in the healthcare proxy law, they would need to have had a prior discussion or about like these kind of withdrawing care, right? Withdrawing.
Only prior discussions, only artificial nutrition, hydration.
So if they haven't had those discussions and they have a healthcare agent, then what happens? Does it
Well,
default now to the Family Healthcare Decision Making Act?
No, if they don't, you're saying if it's an issue of artificial nutrition, hydration, and you have a healthcare agent, then if they don't know your wishes, then they can't act. Except there are, as you said, default to the Surrogate Decision Making Act. The state has confirmed that it's okay if you have someone who is the healthcare agent that is on the surrogates list.
Right.
They could be converted for purposes of that decision. I think the legislature is going to deal with this problem anyway. They are saying that they will, and that they're going to make this, the healthcare proxy law consistent with this Healthcare Decisions Act. So I think that problem is going to go away. But yes, you could do that.
And then if they're not, then you have a problem. If they're, in other words, if they're not.
Yeah, pretty much everyone's on that list. It's slightly documented slightly differently, but it's doable for pretty much everybody. So. Okay, so step one is determining incapacity, and there's an initial determination of incapacity which is made by the attending, and then there's a concurring determination by another attending, and the law actually provides that a health or social services practitioner could make that second determination, but we as an institution decided to require that it be an attending. And then there's also a confirming determination required if the decision was not made at or about the time of the initial determination of incapacity. So if a lot of time passes between when the patient is found to lack capacity and the actual implementation of the medical decision, if there's a long passage of time, and the law does not specify how long it would be, it's really a judgment call, then they're asking you to confirm right before you that the patient still lacks capacity. So the decision-making capacity is defined in the law as the ability to understand and appreciate the nature and consequences of proposed health care, including the benefits, the risks of, and alternatives to proposed treatment, and to reach an informed decision. The attending makes the determination of incapacity to a reasonable degree of medical certainty, including the cause of the patient's incapacity, the extent of the patient's incapacity, and the likelihood that the patient will regain decision-making capacity. When an attending determines that a patient lacks capacity due to mental illness, mental retardation, or developmental disability, then a second physician, assuming this first physician doesn't have these qualifications, must make the final determination of incapacity. The Family Healthcare Decisions Act does not apply to most of these patients if they receive treatment, again, from an OMH licensed unit of the hospital reside in OMH or OMRGD licensed facility or receive services from these facilities. The New York State Mental Hygiene Laws and the Surrogate Court Procedures Act govern medical decision-making for these patients. So these laws have been in existence for a while. So it doesn't take this group of patients out of these laws. They still apply to them in most cases. But again, it's a very complicated relationship between these laws and the Family Healthcare Decisions Act. So if there's any question, call me or our department. We can sort of walk you through it. Step 2 is to determine whether the patient made any prior decisions regarding the withholding or withdrawing of life-sustaining treatment. A prior decision is basically an advance directive, or even a signed consent form that's very specific to the situation, with very clear direction of what the patient wants. It's in writing. It's a signed consent or living will, or it could be a healthcare proxy with written instructions. And it's made orally during hospitalization in the presence of 2 witnesses who sign the form, both of whom are 18 or older, at least one of whom is a health or social services practitioner affiliated with the hospital. If there is a surrogate, there's no need to get consent because the patient's basically already given their consent. But if there is a surrogate that's been identified, then the obligation is to notify the surrogate of the patient's prior decision. Step 3, identify and inform the surrogate. So there are a number of notice requirements in the Family Healthcare Decisions Act. Again, before you go to this list, you just make sure that, again, there's no healthcare proxy. Identify the highest person on this list who's willing and able to serve. This is almost identical to the DNR list, except for the domestic partner. So it's a guardian authorized to decide about health care pursuant to the Mental Hygiene Law, Article 81. Then the spouse, if not legally separated from the patient, or the domestic partner. A son or daughter 18 years of age or older, a parent, a brother or sister 18 years of age or older, and then a close friend. So a domestic partner, again, has the same status as a spouse, and it's defined as an adult in a legally recognized relationship with a patient or a recognized beneficiary or covered person under the patient's employment benefits or health insurance, or if there's mutual interdependence as evidenced by common ownership of a home, personal property, shared income, expenses, or children. So you don't need all of these. And you don't necessarily need to inquire every time, but if there's disputes, if somebody presents themselves as the domestic partner and you have reason to believe that they are, unless you have reason to believe that they're not, and other people recognize them as such, then you move forward. But if there's a dispute and someone else in the family is saying they're not really the domestic partner and I should be the decision maker, then you kind of have to look at this evidence. And then a close friend is defined very similarly to the DNR law, an adult who has regular contact with the patients, familiar with the patient's wishes, and can present a signed statement to that effect. The good news is, unlike the healthcare proxy law, this statement does not have to be notarized, but it has to be signed. Step 4 involves giving notice to the patient. If there's any indication that the patient can comprehend the information, the patient must be notified, one, that they've been determined to lack capacity, and second, that a surrogate's been identified to make decisions on their behalf. If the patient objects to the determination of incapacity, to the selection of the surrogate, or to the treatment decision made by the surrogate, the patient's wishes prevail, unless there's a legal basis to override them, like an emergency. Now, this provision is a little alarming, but we should be reminded that we've been operating under this provision in DNR for years. The DNR law says the same thing, that if the patient has to have notice, if they show any ability to understand, and if they object, their wishes prevail unless it's emergent, and it often is, and we sort of find ways to work around this, but it's there. Step 5 is the clinical criteria for withholding and withdrawing care, and it's set forth in this form that you have. The attending must determine to a reasonable degree of medical certainty that either there's a criteria A and a B. Criteria A is that the patient has an illness or injury which can be expected to cause death within 6 months, whether or not treatment is provided, or the patient is permanently unconscious, and 3 applies to both 1 and 2. The treatment would be an extraordinary burden to the patient. Criteria B is that the patient has an irreversible or incurable condition, and the provision of treatment would involve such pain and suffering that it would reasonably be deemed inhumane or extraordinarily burdensome under the circumstances. So those are the medical criteria for withholding and withdrawing. Some people feel that the burden's too high, but that's how the language reads. And again, this is for a patient without capacity with a surrogate. Step 6, an independent concurring physician must agree with the attending's medical determination that criteria A or B have been met. And independent meaning that they're not on the healthcare team. It has to be somebody who's not currently treating the patient who makes that judgment and documents it. Step 7, for decisions not carried out at or about the time of the initial determination of incapacity, a confirmation of incapacity is required before treatment can be withheld or withdrawn. That confirmation of incapacity can be done by the same attending that did the initial one. It doesn't have to be a different person. And then the decision-making standard under the Family Health Care Decisions Act, once again, the same as under the Healthcare Proxy Law, that the decision should be consistent with the patient's known wishes, if not known, consistent with the patient's best interests. And unlike before, where we had to make an inquiry to make sure there were clear and convincing evidence of the patient's wishes, we can assume that the surrogate is acting in good faith unless we have reason to think that they're not. So then the next step 8 is that the surrogate gives written or oral consent to withhold or withdraw life-sustaining treatment, including CPR, and that consent has to be witnessed by the attending. And step 9 is that an order to withhold or withdraw treatment will be written in the medical record and entered into PRISM. So now I'm going to talk about Form 5, just very brief. I'm not going to walk through it in the same detail, but just to show you what the differences are. This is authorization to withhold or withdraw life-sustaining treatment for a patient with no one to speak for them. It's basically the same steps as Form 4 when they do have a surrogate, except the difference is that you have to document the lack of surrogate, the efforts made to identify a surrogate. Terry Altilio did a great policy on what kind of due diligence is required in looking for family and surrogates. And then it also has different medical criteria for withholding and withdrawing. The standard's even higher, not surprisingly, because it's a person with no one to speak for them. So the medical criteria here are that treatment offers no medical benefit because the patient will die imminently even if treatment is provided, and the provision of life-sustaining treatment would violate accepted medical standards. So it's sort of a medical futility type of standard.
How do they define imminent? Is a time frame? Short
No, they don't.
Say no.
No, it's all medical judgment.
Right.
Yeah. So we have decided as an institution, the law does not require that when you have a patient without anyone to speak for them and you're withdrawing care, that an ethics committee review it. But we felt that in the first year or so at least, we should require that for patients with no one to speak for them, that there's a DNR subcommittee. It can happen quickly by phone, reviews the decision, except for DNR. We're not going to review DNR decisions, but other decisions to withhold or withdraw care on patients with no one to speak to them, for them, will get ethics committee review. And the law does require us to review our policy and procedures on withholding, withdrawing end-of-life care. We have to document kind of how it's going, and so this will sort of help us do that, to have ethics review of these cases. And then there's Form 6, which is about minors. I'm not going to walk through that one either, but I will just tell you briefly about it. Minors are presumed to lack capacity unless an attending in consultation with the minor's parents or legal guardian determine that the patient has capacity to decide about life-sustaining treatment. A parent or guardian has the authority to withhold or withdraw life-sustaining treatment, and if the minor has decision-making capacity, the minor's consent, in addition to consent by the parent or guardian, is required. Usually, a child, I guess up to age 7 is never found to have capacity, but kind of 7 and up might have capacity to assent, which is not really giving full consent, but at least to understand enough what's going on to agree with the decision.
Is the law similar to how it is if somebody lacks capacity in an adult in terms of a minor, where the physician has to explain to the minor that they are relying on the surrogates to make the decision because the minor is found to not have capacity? Do they have to, is there some clause that they have to explain it to the minor past a certain age?
No, there isn't a requirement. It's a judgment call, sort of based on the minor's ability to understand.
Okay.
But if they're under 18, the presumption is that they're a minor. And, I mean, New York has no, the Family Health Care Decisions Act does not explicitly say with minors that you have to give notice. Yeah.
Okay.
And then the law does provide for emancipated minors, which they define as a minor who's the parent of a child. So pregnancy isn't enough, but if you're the parent of a child or at least 16 years of age and living independently, then you would qualify as an emancipated minor. They're presumed to have capacity. The clinical criteria for decision making is the same as for an adult, and would apply in those situations. So just generally about these forms are not medical orders. They should be placed in the medical record when completed. A consent form should be signed in addition if appropriate, and an order should then be placed in PRISM. I'm going to just talk a couple of slides on the Ethics Review Committee. It's a new Ethics Committee configuration. Our current Ethics Committee still exists and is how most decisions will be made, but the law contemplates something called an Ethics Review Committee, which must review cases which cannot be otherwise resolved by the hospital's existing Ethics Committee. The Ethics Review Committee role is advisory with only 2 exceptions where it's binding, which is if the attending objects to a surrogate's decision to withhold or withdraw artificial nutrition hydration for a patient who is not terminally ill or permanently unconscious, then it has to go to Ethics Review Committee and their decision is binding. And also in the case of a decision by an emancipated minor to withhold or withdraw life-sustaining treatment, also binding and has to be reviewed by the Ethics Review Committee. It must be interdisciplinary, this group, and it must have at least 5 members who have demonstrated an interest in patient care issues and medical ethics. At least 3 committee members must be health or social service practitioners, at least one of whom must be a physician and a registered nurse. You have to have one of each. And one of the 5 members must be a person without any governance, employment, or contractual relationship with the hospital, so somebody from outside the hospital. The last slide on this, the Ethics Review Committee must give notice that that it's reviewing the case to the patient surrogate or anyone on the surrogate's list who's been involved in the patient's care, has to provide timely written decision, including reasons for the decision, and it has to permit persons connected with the case, which is really anyone that's had anything to do with the case, to present their views to the committee and to have an advisor for the patient present. And then, of course, the decision has to be in the medical record. So I have a couple of cases that I think would be helpful points of discussion on this new law, and maybe then a discussion can ensue. I don't know if you want to include this or it's fine either. Yeah, either way. Okay, Mr. J has acute lower abdominal pain, is without capacity, and arrives in the ED with his mother, adult daughter, and wife from whom he has been legally separated. His girlfriend shows up claiming to be his healthcare proxy, but she has no documentation with her. Mr. J needs an emergency appendectomy. Is consent necessary? If so, which form should be used and who's authorized to make the decision? Does anybody want to?
It's not necessary. It's an emergency.
Well, that's the question. Should you get consent from any of these people?
It's life-threatening.
Mhm.
Without, if he doesn't have surgery, without.
Right. Well, the thing is, the emergency exception to consent is really only applies if you can't, if there's not time to get consent. But if you have family members with the patient at the bedside, then you always get consent. Obviously, it's a judgment call. You're not going to hold up surgery to get consent. But if they're there and it's easy, then you should get consent. So it's not really it's not an excuse not to get it. It's just that it's a recognition that if there's a time problem, then you don't need to do it. So then the question is, who would be the appropriate person here to give consent?
His adult daughter.
Is he still legally married? He's legally separated, but is he still married?
Yeah, although what the law says, if you're legally separated, then it wouldn't be your spouse. If you're separated but not legally, then they would be. Right. If the girlfriend, of course, had the healthcare proxy form with her, then she would make the decision. Right.
There's no form.
No.
So you can prove.
Right. No, I mean, however, I mean, I've gotten this call once. I mean, if the daughter and the even the wife or any of these, the mother said, "Look, we've all seen it. We know she's the proxy. This is what he would have wanted." You know, I mean, chances are they're all going to consent to an appendectomy anyway. So it's not one of those. It's not a controversial procedure. So it's pretty easy anyway. But you know, we have had situations like that where everyone confirms that they are who they are, and you could possibly move forward that way if there's no dispute. So the forms we would use here would be Form 1, which would be, you know, determining lack of capacity, and then designated one of these people. Obviously, you're not going to take the time to fill out the form if there's no time to, but that's the form that would apply. And then if the girlfriend is, you know, arguably the domestic partner, you know, and if everyone sort of confirmed that was her status, she could be the one to make the decision. So.
But if none of that is that would be the daughter. If
What's that?
If you have the form and they don't agree, so here goes the form. The wife is legally, so therefore, so that would be the daughter, no? Let's say their contestation, we have time for that, and there's no form. Proxy goes away because nobody agrees with that, and she does not have the form. So it would be the daughter, no? The wife becomes a friend. She's legally separated. So
Right. If the wife,
so it would be the daughter.
it would be the daughter.
Okay.
Right. Okay, Mr. G has been hospitalized since his stroke, which has at least temporarily left him without capacity. He has a large necrotic ulcer in his left heel, which needs surgery for debridement. He has no family except a nephew in California to whom he has not spoken for over 15 years. A friend and neighbor of 25 years visits him in the hospital daily but is reluctant to get involved. Who should consent to his surgery? Which forms should be used to obtain consent and to document the decision about surgery?
This is common, isn't it?
This just
We
happened,
see
right?
that all the time.
Right.
We had a similar case.
Any thoughts?
Would it be the friend because the
Reluctant to get involved.
based on the surrogacy then?
Yeah, I mean, the way we wrote this, he's reluctant, but maybe could be convinced. So, I mean, the neighbor's obviously the more appropriate person because he's maintained contact with him and obviously visits him daily. So there's obviously a friendship there, and he would be I mean, actually, both the nephew and the neighbor would be in the same category of close friend, because the neighbor is not, I mean, a nephew doesn't rise to the level of a relative on the list. But you'd probably go to the nephew because he is a relative first, to see if he had a relationship with him and was willing to step in. But if the neighbor can be convinced that he should be the one, he would probably be the better one. But either one could do it. I mean, even though the nephew hasn't had contact for over 15 years, he is his relative, and if he's willing to, he could step in. Particularly if you can't convince the neighbor to do it. So.
What about if he steps in a way that people feel though it's like his choices are not, they don't agree, physicians don't agree with his choices or something like that, then would it mean an ethics review in terms of,
yeah, I mean,
since he hasn't spoken to him in 15 years and
you know, even if he even if it was the neighbor who spoke to him every day, if you have a surrogate who you don't feel is either acting in good faith, or the physician knows the patient better than they do and knows what the patient's wishes are, and they feel the surrogate's not acting on, you know, based on the patient's either wishes or best interests, then yeah, then you have, I think, an obligation to try to work it out, either through conversation, meeting, you know, kind of team meetings with the person, and then obviously the ethics committee can be brought in as well. So, and this would also be Form 1 as well, and Form 2, which is about documenting the friendship if you need to. Okay, last case. Miss P is a 68-year-old widow who comes to the hospital with chronic kidney disease and end-stage lung disease. Her live-in partner of 3 years is out of town on business, and Miss P arrives in the ED with her daughter and 14-year-old grandson. In the presence of her grandson, as she is struggling for air, she tells the house staff officer that she's willing to be intubated, but she does not want CPR if she arrests. By morning, Miss P's kidneys are failing, and it is determined that she lacks capacity. Her partner calls to speak to the attending and insists that she be given dialysis. The daughter is less certain that dialysis is indicated. Her physician recommends that dialysis be attempted to determine whether capacity can be restored. The daughter disagrees. Can dialysis be done? If so, who can consent? Which form should be used? Who's the appropriate surrogate? So.
There's only daughter. I missed it.
Here, back here it says she has a domestic partner who's not there but available by phone, and she comes to the ED with her daughter and her 14-year-old grandson.
Domestic partner.
Right. Yeah, I mean, she trumps the daughter, but as we all know, as a practical matter, you're not going to make a decision about withholding or withdrawing care if you have two people that close to the patient who disagree. You know, it's easier. That hierarchy makes, in some ways, makes more sense for beneficial care, for indicated care, because you know, it just helps you decide who's going to sign the consent form. But when you're withholding or withdrawing care, you don't have to get consensus from everybody on the list. But if you have a domestic partner and an adult daughter, it would be difficult to move forward if the adult daughter is disagreeing, even though the domestic partner is higher on the list.
But if medically it's a separate issue, because in end-stage lung disease, intubating patient is not going to make patient much better. Unlike the patient will come out of ventilator, it makes things more like complicated for patient.
Mm-hmm.
So even we wouldn't offer dialysis because the disease is terminal.
Mm-hmm.
So
yeah, no,
it is very complex.
It's very complicated. I mean, this this set of facts, which is nuanced as a real situation, but the idea is that in this case, the attending just wants the patient to be able to make these decisions. So the hope was that if they did a brief period of dialysis, that she might regain capacity to make her own decisions, which would be, you know, more ideal. But so in this situation, are there any prior decisions that can be relied on?
Yeah.
Well, they talk about CPR.
Right.
Before she last capacity.
It says, in the presence of her grandson, as she's struggling for air, she tells the house staff officer that she's willing to be intubated, but she does not want CPR if she arrests. So does this rise to the level of a prior decision?
I think
Yes,
so,
she
because he
may
said
have.
orally if it's witnessed or.
She expressed her
Yeah.
wishes.
Yeah. No, I think it's very clear. The problem with this scenario and why we put it in this way is that he's 14, and what the law says is if it's an oral prior decision, it has to be witnessed by hospital
18,
staff
correct.
and somebody else 18 or older. So,
Yeah.
you know, it's sort of silly, but that's how it would play out
So therefore it wouldn't
potentially.
count?
Well, it wouldn't count as a
House staff is
you're going to end up in the same place, because it wouldn't count as a prior decision in the sense that you could then move forward without the surrogate's consent,
Right.
but it would be an oral advance directive. So then the person acting as the surrogate could, based on the patient's known wishes, which here we know,
Yeah.
say no to CPR. But that, you know, so you'd end up in the same place probably, at least in this set of facts, but you wouldn't treat it as a prior decision. If it's a prior decision, you only give notice to the surrogate, but you don't even have to get consent. Yeah. They're oral advance directives, so there are. And
it should be okay then communicating with the adult daughter and the domestic partner, and come up with, based on the medical condition, come up with consensus
Right.
decision.
right, that would be the
Like
way to
makes
go.
sense to both sides,
Right,
to the medical team and the
right,
family.
right. Yeah, that's always the best. So this is the same case. What if Miss P had been able to speak and she objected to the determination of her incapacity or the choice of surrogate? How would we handle that?
Well, we have to document capacity,
Mhm.
you know, by professional. If he, you know, the treating physician unable to do that, can call counsel.
But this is if she still doesn't have capacity, but she's able to speak.
Right.
Mm.
She may be, you know,
Mhm.
she may have like mental illness or
Mhm. Right,
can
right.
object or delirious. You
Mhm.
know? So you document that patient does not have capacity, medically,
Mhm.
and
Could you go? Do you think you could go forward with dialysis on the basis that it's an emergency, or no?
I
Hmm.
wouldn't.
You wouldn't want to, right?
Myself, no.
I'll skip over the next one. It's just repeating the criteria. If a nephrologist on the team volunteers to give the concurring medical opinion with regard to whether or not to stop dialysis, can the opinion be relied on?
Yes, we do respect the nephrologist input.
This though, see, it says the nephrologist on the team, and that would not be an independent opinion. So you'd have to, I mean, a nephrologist, of course, is the right person medically, but you need to get a nephrologist who's not been on the team, who's not been
second
treating this. Yeah,
nephrologist.
the second one has to be somebody who's independent. If an ethics consultation is called, is the process any different than it was prior to the enactment of this law? And the answer is that the process shouldn't be any different. We would go through, it says you have to go to the Ethics Review Committee if the issue can't be otherwise resolved, meaning under our current ethics program. The problem's going to be, we haven't yet had an ethics consultation under the Family Healthcare Decisions Act that requires the Ethics Review Committee. But if patients become more savvy about this and say, you know what, I want an Ethics Review Committee, I want all 5, I want somebody from outside the hospital, then we would have to convene one.
Right.
But we don't have to go for, and someone from the inside could demand one too. If there's disagreement about something, they could say, I don't agree with what our ethics consultation said, I want to take it to the next level, I want an ethics review committee review, and then we would have to put one together for that situation as well. So.
Nephrologist can say, oh, we have to continue dialysis, then daughter says no dialysis, then you have a problem. And then ethics should be
Okay.
on board.
Right, right. So any questions